We have talked at length on this program here at Wedding Industry Law about arbitration and about litigation and whether these options are right for you. And the answer is always, it depends. Today, we are going to talk about mediation, the benefits of mediation, and whether you should require any dispute with your client be resolved through mediation. Peace. Welcome back to Wedding Industry Law. My name is Rob, and I am your host for this program. And in today's video, we're going to be talking about mediation, what it means to mediate, and whether or not you should require mediation in your client contract. But before we do, a couple things. Number one, be sure to like and subscribe wherever you get your podcast from. If you're watching this on YouTube, which I hope you are, be sure to hit the notification bell at Wedding Industry Law. Be sure to leave a comment down below. I would greatly appreciate it if you have ideas for content in the future. One more thing. If you are on Clubhouse, and I know that a lot of you are, please be advised that I host Wedding Industry Law Hour on Clubhouse every Thursday, 4 p.m. Eastern, 1 p.m. Pacific, where I answer questions from all of you about anything having to do with the legal side of running a wedding business. And so that's on Clubhouse. Check me out. I'm at Wedding Lawyer on Clubhouse. And with that, let's get into it. So if you have a dispute with a client, there's only a few things that you can do. I mean, this isn't the Wild West anymore. You can't form a posse up and go, get into a gunfight at the OK Corral to get your money back from a client, or vice versa. We are typically relegated, as they would say, to a few different options to resolve disputes. The first one we've talked about many times in this program, and that is suing your client, suing somebody in order to recover from that person. That's one way to resolve a dispute, letting a judge or a jury resolve it for you. Determine the amount of recovery that you would be entitled to, if any, or defending you from somebody that is seeking recovery. The second option, which we've talked about a couple times, and I will actually here link down below the episodes about arbitration. I'm pointing down, so you can follow the link down below or in the show notes. And then to my left, this is actually me talking about arbitration here over my shoulder. But anyway, I talked about that in previous episodes. Be sure to check those out because I go into arbitration at length about why that might be a good idea or a bad idea. Hint, no spoilers, but typically it's probably not the best idea for your business, and find out why in those episodes. So arbitration is a way to resolve your disputes in private through a neutral arbitrator. It is not a court of law. It's not a jury. It's literally a private means of resolving an issue. You plead your case. You agree to be bound. Most of the time, you agree to be bound by the finding of the arbitrator. Okay, now, what is mediation? How does mediation work, and how does it compare to the other two? Mediation typically is a non-binding way in which parties can attempt to resolve their dispute. So most often mediation is a way to resolve a dispute by having a neutral mediator, an independent person or persons, but an independent mediator, listen to one side complain, listen to the other side complain, and then throughout the course of the day, that mediator's job is to attempt to find a resolution or a settlement. So if the mediator does his or her job, then there will be a resolution. In other words, the dispute will be settled, and there will be some form of a binding settlement at the end of the day. Now, mediation is not always effective. However, it's effective most of the time. 99.9% of cases settle. In most cases that settle, at least within litigation, in my experience, it's settling through some type of formal mediation process, meaning that, as I just mentioned, the parties get together in a room, there's a mediator, and the mediator's job is to go back and forth between the parties. Once the parties go off and caucus in different rooms to try to bring them hand in hand into some type of agreement. Now, great, Rob. What does this have to do with my contract? what this has to do with your contract is, I typically think that the best option for you is to be able to keep the ability to sue your client in small claims or in your typical court of regular jurisdiction in your pocket. Like I typically don't like people making other people arbitrate. I like litigation. However, that's not to say that requiring the parties to mediate prior to any filing of litigation is not okay. I think that's definitely something that you can consider. So in other words, before anybody can sue one another for any reason, the dispute must go through a formal mediation process, as I've described. That is what we would call a condition precedent to filing the lawsuit. All right, Rob, why even go through that rigmarole? What are the benefits of mediating a dispute as opposed to arbitrating it or going through the court process? Number one, it's informal. Most of the time, you're not having to, go before a judge, put a suit and tie on, formulate these massive arguments and things like that. You go, you say your piece to a mediator who hopefully will have experience with this type of dispute. The other side does the same thing. And then it's in the hands really of the mediator to understand the case and to get it done. So in other words, it's not a process that's lengthy. It's not a process that requires, a substantial amount of time for the attorneys to do discovery, all this kind of stuff. Essentially, you're taking the information that you have as you have it. You're formulating your argument. You're letting the mediator know what you think that the case is worth. The other side's doing the same thing, and the mediator goes in between. So it's not as formal of a process. Now, the next thing is that the mediations tend to be successful because it allows both parties to see where they're being stupid. Now, a judge is never obligated to look at one party and go, "Man, you better settle this because you look like a butthole." Okay, that's not going to happen in a court of law most of the time. At least, hopefully, not. Knock on wood, not to me. But a mediator most certainly can take a party aside and go, "Hey, if this goes to court, you're going to lose." Okay. So you should think about that when you're, offering whatever XYZ. So in other words, having a neutral person whisper into the ear of the other side, or maybe even your side, maybe the mediator will speak to you and say, "Hey, why don't you calm down? This case isn't the burning building that you think it is." In other words, you've got somebody there that has no dog in the fight, that has experience in these type of situations, that can really tell you what you can actually foresee or what is foreseeable with the outcome of this actually goes to litigation. So that's the other thing. So you got not quite as a formal process, a little quicker. You've got somebody that can really speak truth to the parties about what the case is actually about as an independent person, what they're seeing as they come to it. And then the other portion of this is that there is a level of risk aversion, meaning that you, by settling this case, even if you settle it for less than you think that you should have, the mediation is going to be the only time that you have any control over the recovery. Because if the case goes to an arbitrator, if it goes to a judge or a jury, that's out of your hands. The jury, the judge, or the arbitrator is going to be deciding how much recovery you should get, if any. So by being actually a part of the process, you can mitigate or lessen the risk that comes with the recovery not being in your hands. It's the only time that you put your hand in the pot. So that's kind of the benefits of mediation and the benefits of, trying to come to a resolution in that fashion versus the normal court system. So by requiring it in your contract, essentially you're getting the parties to kind of, the first bite of the apple of resolution is going to be mediation. And like I said, in other podcasts, mediation does have some costs. I mean, you had to pay the mediator. Okay. So think about it this way. that let's say that your contract, is worth, let's say that this $5,000 is on the line. Okay. And if you didn't have mediation as a requirement and you had to sue somebody for $5,000 or they were suing you for $5,000, then you're going to go to the local small claims court or the county court or whatever of general jurisdiction. You're going to pay your $100 or $200 or $300 to file the case, wait for your hearing. Maybe you pay for an attorney and that has its own cost. Maybe you don't. And that's it. Those are all the filing fees that you have or the administrative costs that you have. With mediation, typically, the actual mediation itself doesn't cost anything. You have to actually pay the mediator, though, and mediators are by the hour. So you and the other party would be splitting the mediation costs most of the time, depending on what your contract clause says. So if it's $300 an hour, $400 an hour, $500 an hour, cut that in half, blah, blah, blah. So there is that cost, but you have to weigh that against the idea that there's a good chance that the mediator, if they do their job and they're good, will resolve the case. Like there will be no dispute left after the mediation is done most of the time. And so whatever amount you have to pay the mediator, you have to weigh that against what you would pay an attorney or whatever the cost is in time and money filing a lawsuit. So at the end of the day, again, for reasons that I won't go into, I'm not a huge fan of arbitration for wedding industry professional contracts, but in terms of alternatives to filing lawsuits, I think that if you decide that I want my client to have to mediate formally before they can file a lawsuit, I think that is acceptable. I don't necessarily think that's a bad thing for you. It might not be for everybody. I'm not saying that you have to do this. I'm just saying that because this question has come to me from people that watch this program. Well, Rob, what are some things that are alternative to filing suit that we can do? And I would say that this is one of them. This is something that you can do without having to file a lawsuit, right? So anyway, I digress. I hope that you found this a little bit enlightening. Hopefully you learned a little bit more about what mediation is. You learned a little bit more about the benefits of it, maybe some of the downsides to it, and the fact that this is something that you can work into your contract without it being a detriment to your ability to actually go forward with the lawsuit if mediation is unsuccessful. So if you did find it helpful, please be sure to like and subscribe, hit the notification bell if you're watching this on YouTube. If you're listening to this as a podcast, meaning just the words, the audio, then please review the podcast wherever you are listening, because that helps in the algorithms. So new videos every week. Be sure to check them out as they come out on Mondays. And with that, folks, we'll see you next time.